thank you everyone for coming. Today we have a debate about applying Israeli law to at least part of the Israeli settlements in the West Bank. It is a contentious issue. I'm here with my co-president of the Federal Society here at Case Western Reserve University virtually. And we'd like to thank everybody for coming. We got a great turnout today. And so without further ado, Dean Scharf, would you like to give an opening remark or two?
I've known Eugene for years. He's one of the world's preeminent experts on international law. Now, Eugene is going to be debating today against our own Associate Dean, Avi Cover. And we love this kind of format. I mean, we're always trying to do things a little more interesting and exciting. And you guys that are Zooming in today are in for a treat because they're both great debaters. Avi is the director of our Institute for Global Security Law and Policy. And he also ran our Human Rights Clinic and spent time in Israel working on cases involving the West Bank. So he also has a personal connection to this. He's the former senior counsel at Human Rights Watch, and he does a terrific job on these issues.
Now, today's debate is titled Applying Israeli Law to the Settlements. Is Israel within its rights? Our two participants are going to grapple with the longstanding controversy surrounding the future of the West Bank. As a little background, control of the West Bank has been referred to as Judea and Samaria and has been a contentious issue in international law ever since the formation of the Israeli state in 1948. So starting in 1920, following the Ottoman rule in the region, the British controlled an area even larger than the modern-day West Bank, covering much of modern-day Israel and Jordan, which was known as Mandatory Palestine. These boundaries were set by the League of Nations mandate for Palestine and were thus recognized under international law. After the formation of the official Jewish state in 1948, following a war of independence, Jordan occupied the West Bank for years before ultimately losing control of it to Israel in 1967 during the Six-Day War, when Israel won yet another existential war against several neighboring states. Since then, Israel has instituted a quasi-military form of governance in the area, while allowing various portions of the West Bank to be governed by the Palestinian Authority. Due to the Oslo Accords that initiated in 1993, famously created between Bill Clinton, Yasser Arafat, and Yitzhak Rabin, the Palestinian Authority was thus created, and the West Bank was carved up into three main areas. Area A, for Arab control, administered by the Palestinian Authority. Area B, for Arabs, but administered by Israel. And Area C, for Israelis only, falling under different versions of Israeli law. Efforts to end the boundaries created by Oslo were unsuccessful as Palestinians refused to recognize the state of Israel and rejected multiple peace deals offered by the left and right-wing Israeli politicians. Claiming human rights abuses by the Israel Defense Force and land theft by Israeli government, Palestinians launched their own terror attacks against the Israeli civilian and military targets throughout the 20th century into the present day. In fact, many terror attacks on Jewish civilians even occurred before the formation of Israel, dating back to the 19th century. Thus, this issue has been quite contentious over time. At the same time, Israelis who built residential communities in their ancestral homeland of Judea and Samaria have been labeled by the international community as human rights violators for building settlements on stolen Palestinian land. Many UN bodies have passed resolutions condemning the settlements, as well as Israeli policies that support the settlements to exist. In light of recent events with Israeli Prime Minister Benjamin Netanyahu hinting that Israel may ultimately apply formal Israeli law to parts of the Israeli settlements, ending the status quo, a moment might finally come in the near future where Israel would ultimately decide to apply its national law to approximately half of the Jewish Area C portions of the West Bank. While Netanyahu had recently suggested such a plan would be executed earlier this year, he tabled the plan as a precondition for Israel to enter into two historic peace deals, one with the UAE and the other with Bahrain. Our current debate will likely cover a broad array of legal and political categories. And since this issue touches on international law, sovereignty, human rights, security concerns, just to name a few, the topic of this debate will not just be whether Israel will apply its laws to Area C, but what is the legal status of Israel's current presence in the West Bank, what annexation actually means in this context, and most importantly, what the legal implications are going forward. So without further ado, Professor Kontorovich, I'm going to give you 12 minutes to give your opening remarks.
Thank you. Thank you all for being here. We have a big subject. It's a subject I give hour and a half lecture on also, and don't cover all the points. But the I'm going to focus on the big picture question of the legal status of Israel's presence and control in the West Bank, Judea and Samaria. And I think the answer to that question is also dispositive of the answers to more specific questions like the legitimacy of Israelis living there or building houses. That's the settlement question, the question of the application of Israeli law, which is widely described as the question of annexation, a term that I think is inaccurate. So very broadly, I will try to sketch the legal arguments concerning Israel's status in the territories, the legal status of the territories. And this is different from the political question of what Israel should be doing there, what a good diplomatic solution is, what would be good for peace in our time. But legally, the question is what typically Israel is referred to in many international discussions as an occupying power in the West Bank. Israel is occupying the West Bank. And occupation is an international legal term. It is neither good nor bad in international law. It is a neutral term, but it refers to a specific legal condition. And that if one is an occupying power, one's authority in the area is limited compared to if one were a sovereign. So to ask whether Israel is an occupying power, one needs to first understand what is the status, what is an occupying power, and what was the status of the territory when Israel took control of it in 1967. So international law defines occupation as when a country in a war with another country takes territory by military force and then comes to administer it. Not just like takes it in a transitory way, but gets behind the desk in City Hall and starts governing it. So that is an occupation. So there was a war with Jordan. That would be the relevant war. And Israel did indeed take control of this territory that had formerly been in possession of Jordan. But that does not necessarily mean it's an occupation, because an occupation does not occur anytime a country takes territory in war. So, for example, we just see it right now before our very eyes. If you're following the news from Nagorno-Karabakh, as I'm sure you are all glued to your seats, because this is the most relevant and interesting live case of a conflict about occupied territory. Azerbaijan has, in this very, very serious war that they're having now, with probably thousands of lives lost, has taken territory that has been under Armenian control. Has taken territory that had been under Armenian control. Not only had it been under Armenian control recently, it had been under Armenian control since both Armenia and Azerbaijan became countries, since the independence of Armenia and Azerbaijan. So, and even though in this war between the two countries, Azerbaijan has taken territory in which no Azerbaijanis reside, and which has never been under the control of the Azerbaijani government since for 20 years, since the independence of both countries, I will bet you that not a single country in the world will describe Azerbaijan's taking over this territory militarily as an occupation. And they will be right to do so, because Azerbaijan is not occupying these territories. Why not? Because you can't occupy territories to which you have a sovereign claim. You can only occupy enemy territory. You cannot occupy your own territory. This is not a question of like what happens if nobody owns the territory. It's a question of a territory to which one has an actual sovereign claim, you cannot occupy. Yeah. So if for example, just to give an amazing example, if Ukraine, in an offensive in 15 years, dislodges Russia from Crimea, nobody will say that Ukraine is occupying Crimea from Russia. They've just retaken their territory, even though it had not been under their control for a very long time. In the extraordinary case of Azerbaijan, it had never been under their control. Now, the case of Azerbaijan and Armenia actually looks a lot like the case of Israel, and I want to tell you the law through the lens of Nagorno-Karabakh, that is Israel, Armenia, and Azerbaijan, and then we'll apply it to Israel. Because one big mistake people make in international law when they talk about Israel is they don't look outside of Israel to find out what the law is. They find a law that is internal to the one case that they care about. Now, that's not a system of law. You can only look, if you have a case that you want to decide, status of the West Bank, you have to learn the law from other cases, from prior cases, from other precedents. But Nagorno-Karabakh illustrates this very well. So the Armenia and Azerbaijan, this is not what you guys signed up for, but it's exactly what you need. Armenia and Azerbaijan were both republics of the Soviet Union. So the Soviet Union of Soviet Socialist Republics was composed of 16 Soviet Socialist Republics, which were the top-level administrative units in the Soviet Union. They were all governed from Moscow, of course, but they were the top-level administrative units, much as a province is a top-level administrative unit in the United States or in Canada, and a state is a top-level administrative unit in the United States. The Soviet Union collapsed in 1991 and ceased to exist. And then all these new entities wanted independence. The former, they all claimed their independence, Armenia, Azerbaijan. And the question is, what would be the borders of these new countries? Because the borders that had been drawn by the Soviets did not correspond with underlying demographic or even historic realities. They were arbitrary, right? They were done by the Politburo. They did not match where people lived. In particular, Armenia is right next to Azerbaijan, but then a little bit into Azerbaijan, like separated by Armenia territorially, was a district called Nagorno-Karabakh, which was not a top-level administrative unit. It was like a county, like a special autonomous zone, and it always had a majority Armenian population, even though it was in Azerbaijan, and had many historic connections to historic Armenian kingdoms. So there was Azeris living there, but mostly it was ethnic Armenians. And they wanted this to be part of Azerbaijan, of Armenia. Why? Because mostly Armenians live there. They said it should be governed by Armenia. So they made a claim very similar to the Palestinian claim of ethnic self-determination, to draw borders, say, we're the majority here, so we should get to control our fate within this territory. The international community did not agree with that view, because in international law, there is a very clear rule for figuring out the borders of new countries. And the rule is simple and clear. It has one factor, only one factor, because when new countries are created, which is not infrequently, it is important to have an algorithmic, simple, not context-dependent rule to figure out new borders, because because there's always ethnic groups, religious groups on either side who want to be with the sovereign on the other side. So the rule is very simple. It's applied all over the world, Latin America, Africa, Europe, Asia, and it's called the uti potestatis principle, uti potestatis juris. And it says when a new country is created, not a new government for a country, but when a new country, either because of the breakup of an empire like the Soviet Union, or because of decolonization or other circumstances, the new country automatically gets the borders of the last top-level administrative unit. So it makes it easy. What are the borders? When Latin American countries have disputes about borders, they're even looking up 16th century Spanish gubernatorial maps to find out what those borders were. So when the Soviet Union collapses, the borders of the new countries were the borders of the top-level administrative units, the Soviet Socialist Republics. That means that this Armenian enclave wound up in Azerbaijan. That's not what the Armenians there wanted, but that international law doesn't ask what the people wanted. International law values clear borders. Now, in fact, Armenia didn't like this. They fought a war with Azerbaijan and they won. And from day one, Armenia always controlled this territory. They sort of took it like at the very beginning of independence, and it has been administered by Armenia. There has never been Azerbaijani control there. Nonetheless, the international community regards it as Azerbaijani territory occupied by Armenia, even though Azerbaijan never exercised control, and there are no Azeris living there now. Let's apply this legal principle to Israel. Israel became a state in 1948. Most of us can agree on that. Israel became an independent state. What was the last top level? And then that's the only question we ask. We don't ask what opinions did people have about what should happen? What did the UN recommend? The only question is, the day before independence, what was the last top level administrative unit in the area? And the answer is very simple. It was the Mandate for Palestine issued by the League of Nations.
2 minutes left.
Yep, good. The mandate for Palestine issued by the League of Nations. If you were to ask anyone on January 1st, 1948, a few months before Israeli independence, what are the borders of Palestine, which did not have any connotation of an Arab state, just a geographic designation, they would say the entire area that today would include Israel, the West Bank, and Gaza. There was no separate idea of the West Bank. Those automatically became Israel's borders. You don't have to claim them. You don't have to do anything. Those become the borders. Jordan immediately invades because they didn't like it. They wanted a different regime for the Arabs living there, much like Armenia invaded Azerbaijan at the very beginning because they wanted a different regime for the Armenians. And Jordan occupied the territory for 19 years. They occupied it. But military conquest, military occupation does not change borders. Much as we've seen that Armenia's occupation for the entire independent existence of Armenia and Azerbaijan of Nagorno-Karabakh has not changed the borders. And so when 20 years later Azerbaijan retakes this territory, or 19 years later Israel retakes this territory, it would not be an occupation, but a reclamation of friendly territory. Even if, and that's my main argument. Second argument would be, even if for some reason you were to say an occupation began in 1967, an occupation in international law never lasts longer than the actual war. Now, the war, that's not defined by the shooting war, but by any kind of formal or informal hostilities. But certainly a peace treaty ends a state of occupation. That's why after America signed a peace treaty with a new Afghan government that it imposed, it was no longer occupying Afghanistan, even though, of course, there were many soldiers there that were running Afghanistan in many ways. Even though America had troops in Germany in huge amounts throughout the 1980s, it was not considered an occupying power after the creation of the Federal Republic of Germany, with which it signed a peace treaty. Israel, so this is not just my opinion. The famous State Department memo, which concluded that Israel was an occupying power in 1977, the one which the State Department retracted and overruled in November under Secretary Pompeo. But this famous document, which everybody knows for its punchline, its conclusion, that Israel is an occupying power, said, of course, if Israel were to make peace with Jordan, then there would no longer be any state of occupation. Now, they wrote that in 1977 when no one thought they'd make peace with Jordan. In 1994, Israel made peace with Jordan, and that part of the opinion has been very deeply forgotten by people who previously believed in it. So even if there was an occupation, it wouldn't last past 94. But in any case, if you look at how other conflicts that are directly analogous are treated, we would see this would not be considered occupation. And that is my time.
Okay. Thank you very much. Dean Cover, you're recognized for 12 minutes and change.
All right. Thank you to the Federalist Society. Thank you, Joseph and Patrick, for putting this event together. And thank you, Eugene, for joining us. I'm only sorry it has to be virtual. I hope we can host you here in Cleveland in the very near future. So I think there's a lot that I agree with that you've set out forth, Eugene. I think I agree in principle, I suppose, as to rules of state succession with respect to borders. And certainly, I think what is critically at issue here is the role of Israel as an occupier. Indeed, as you noted, sort of the term that is generally used to characterize Israel's occupation and the applicable law here is that of occupation. Israel is regarded as a belligerent occupant, and it doesn't necessarily have to have that negative connotation. I do, I'm reminded in some of what you've said of Oliver Wendell Holmes's observation that the life of law has not been logic, it has been experience. And so I think it's important, notwithstanding, I think some of your very important points, to look at practically how the law of occupation has been applied, not just by the international community, not just the International Court of Justice and the United Nations and the General Assembly, but Israel. Israel's own High Court has treated the situation in the West Bank as an occupation and has examined Israel's role as an occupier and applied those obligations in making a legal analysis. So, briefly, just to address the claim, I guess one question I would ask that I hope we can engage on is if indeed the law of occupation does not apply here, which it seems that may be your conclusion, what law does apply? What then does govern Israel's relationship to the Palestinians, Israel's relationship to the West Bank, the Jordan Valley, and the like? But, I suppose I have to take issue at some regard. We have the British mandate, and of course, then the UK evacuates. And we do have, I think, a very important partition plan that is introduced, Resolution 181. And it actually sets forth very detailed boundaries, right? The partition plan. Now, to be sure, there is a war in the wake of that plan and in the wake of Israel's declaration of independence. But that plan set forth very clearly the notions of having a national state for the Jewish people and a national state for Arab people. And I think it's also clear through various international resolutions, but also agreements between the PLO, PA, and Israel, that they have all worked on this principle that Palestinians have a right to self-determination, have territorial rights. And some of those rights were going to clearly, those territorial rights encompass portions of the West Bank. So to get, though, then to the law of occupation, you can find it both within customary law, that is to say, law that is not necessarily pursuant to treaty. Countries don't need to be parties to a treaty, and the principal regulation here are the Hague regulations that are applicable. And the Israeli High Court, for example, in addressing various actions, scores of actions that have taken place in the West Bank, have continually applied the Hague regulation as customary international law and understood that Israel is to be regarded as a belligerent occupant, and it has obligations attendant to it. Those obligations under as an occupier are principally to maintain the status quo. The occupier functions as a custodian of the civilian population and has obligations not to disrupt that status quo, to maintain the situation. Now, to be sure, some of those obligations relate to security as well, but that is the principal overarching mandate that the belligerent occupant has, and that's what Israel has. Embedded in these principles then are, as Eugene sort of alluded to, there is a prohibition on acquisition of property via conquest. Right? That would apply in Nagorno-Karabakh. It applies here as well. Right? And it courses through the relationship between Israel and the Palestinians. Right? It is there. It is embedded starkly in Resolution 242, right, which was issued by the Security Council right after the Six-Day War, and holds, it emphasizes the inadmissibility of the acquisition of territory by war, and it called for the withdrawal of Israeli armed forces from the territories occupied in the conflict. Right? This has been underlying each and every agreement, whether it was the Camp David Accords with Egypt, the 94 peace treaty with Jordan, the Oslo Accords and the interim agreements and the like. Right? This is a basic principle of international humanitarian law that the Israelis have seemed to, in general, recognize. So really, there are these three principles, right? The prohibition on acquisition of property, the obligation of the belligerent occupant to maintain the status quo, and I think we have to be cognizant all the while through this of a principle of self-determination, right? These underlie the analysis. So what then does this plan of annexation mean? I mean, I think if we're looking here, I think this is the issue that is joined here. Is it a violation of these principles? And I think there's no question. I mean, we've seen certainly the anger and various vituperative statements sometimes made by the international community that an annexation of land, whether it is the 30% of the Jordan Valley and various, which would also encompass, by the way, at least 10,000 Palestinians. I think there is no question under international law that is a violation. One need only look at the International Court of Justice's opinion from 2004, its advisory opinion regarding the legal consequences of the wall, where the court there held, first off, it held that the settlements themselves are unlawful, but that the wall, notwithstanding arguments in support of security, violated these obligations as set out for an occupier, in particular, certain provisions of the Fourth Geneva Convention that prohibit the movement, the transfer of one's own population into occupied areas. And the court struck down the wall on a number of other bases. But I think it's also clear that we have a basis for suggesting that the Israeli high court jurisprudence also might look askance at these actions, or certainly the legal architecture that is built in terms of recognizing the obligations of a belligerent occupant. It is hard to square annexation with that. The Israeli High Court, as I noted, has held that the Hague regulations are binding. And indeed, when it does apply international law to Israeli military action vis-a-vis Palestinians in the occupied territories, it applies this analysis of proportionality. Right? It generally is looking, security interests may predominate, but are they proportionate? Right? Are the injuries, the means taken, are they proportionate to the security objective, the safety of Israelis? Now, I should note, I think importantly, the court has made clear that in analyzing national security needs of Israel's military actions, such as a seizure of Palestinian territory, it will not, I quote, consider notions of a greater Israel based on Zionist ideology regarding the right of the Jewish people to settle in Judea and Samaria, right? That is in the military context of the occupation. That is not a security basis. Now, it is certainly the case that in most instances, the Israeli High Court has upheld Israeli actions, including seizure of land. We sometimes see what is sort of a bootstrapping, not addressing, the court is generally reluctant to address the legality of the settlements themselves, right? That is sort of a political question. And so it often legitimates security actions taken to protect Jewish settlers. So while one might look to the court as a check, it is in many instances, I think, more of a legitimizer. And that is certainly a critique that has been levied at the court over various times. Look, in terms of what we see here, in terms of the respective actions, you can look at the agreements themselves, Oslo, which provide that no side shall take any step that will change the status of the West Bank and the Gaza Strip. That language, right, dating back to the 90s, right, is significant. We can argue, and we can take this argument and say that Israel still has sovereignty over this territory. But that agreement, the text of that agreement belies that argument, right? We can't ignore the fact that for over 53 years of occupation, Israel has not moved to annex the West Bank. I think there is significance in that. So we're a high court to address this proposed annexation now tabled. I have no doubt that it would declare it unlawful. I have no doubt we will see continued condemnations. I don't think we will see a high court ruling here. I think it will be viewed as a political question. But it's worth noting the court has, in numerous instances, struck down Israel's expropriation of land, the taking of private land, and found that it was not done out of the military necessity argument had not prevailed. And just earlier this summer, the court struck down Israel's retroactive legalization legislation, which would have held that settlers who had illegally built homes on Palestinian land in the West Bank, where they did so unknowingly in good faith, that law actually presumed good faith if the state supported it. The court struck down that law, right? And so we do see at least some protection of Israeli interests. But I would not be honest with you if I didn't say that, regardless of annexation, this occupation is deeply problematic. I don't disagree with the notion that this occupation has gone on far too long, and indeed perhaps exceeded the boundaries of what we think of as occupation law. And indeed, then we have to ask, what rights then is Israel violating? Do we apply international human rights law? And I think this bleeds into inevitably the political question as well. If annexation, what rights will be afforded the Palestinians? Will we have a one-state solution, a two-state solution? What does that mean for a democracy of Israel? What does that mean for a Jewish state of Israel? I think it is hard to square all of those elements.
Thank you, Dean Cover. Professor Kontorovich, 5 minutes for a quick rebuttal.
Yeah, to recapitulate, we cannot speak about the Israeli occupation and the legality of settlements because there is no occupation, not as the United Nations sees it, but if you take the general rules that govern sovereignty and territories, the existence of belligerent occupation, and apply them to this context. Now, for example, Dean Kappel mentioned the United Nations Partition Plan. This was a proposal by the General Assembly in 1947 to partition mandatory Palestine into an Arab and Jewish state. The proposal was not accepted by the relevant parties, not just the Arab states, most relevantly the British, who thought it was unworkable, and so it was never implemented. Again, turning back to the general rule of international law, uti partidetis juris, it says the borders of the last administrative unit, not the borders that someone proposed for the last administrative unit. And when you look at other League of Nations mandates, there's nothing magical about the UN partition plan. Partition of one kind or another was proposed for many UN or many League of Nations mandates. For Syria, certainly, with many proposals and many actual attempts to partition it into different ethnic states. For British and French Togoland, and for other territories. For Iraq, where there was a proposed partition to create a Kurdish state. And in the end, the proposals that are not effectuated have no bearing on the new borders of the new state. They're just ideas. It's true that the United Nations has spoken about the inadmissibility of acquisition of territory by war. But that is exactly what the argument that Israel is an occupier would do. It would legitimize. Because everyone knows that the West Bank was not part of Jordan before it invaded in 1948. So to say that Jordan's invasion and occupation of the West, of that part of mandatory Palestine, permanently changes the legal regime in that territory, that as far as Jordanian troops got, now Jews or Israelis are somehow disabled from living, is in effect to give retroactive validity to offensive conquest. To say that the Jordanian offensive, the Jordanian conquest, permanently changes borders and creates new legal lines. That would be giving some admissibility to conquest. Now, the Israeli Supreme Court has indeed heard many cases in the West Bank, but I think it's very important to stress that they have never, ever conducted a legal analysis as to whether the territory is occupied under international law, and they have never concluded that it is occupied. What they have done, however, so the Israeli government, when they took control of this territory, they had the same question as Dean Kava says, what rules should we apply? And they didn't want to make a whole set of new legislation. So they said, as a matter of grace, as a matter of voluntariness, we will apply parts of the Geneva Convention voluntarily to this territory. Now, when you say parts, by definition, you mean we don't think it applies de jure. Right? When they applied Israeli civilian law and incorporated Jerusalem, Eastern Jerusalem, into Israel, the Israeli government quite clearly showed they don't believe that this is an occupation, because you can't do that in an occupation. But they said, for lack of better ideas, we will temporarily apply parts of occupation law just so we have what to apply, because Israelis hate the idea of legal gaps. It frightens them. The Supreme Court has this very strong notion of administrative law in Israel, that anything the government says or undertakes is completely binding on the government. So once the government says we will voluntarily apply parts of occupation law, the Supreme Court says, since this is being treated as an occupation, but it's not being treated as an occupation as a matter of de jure international law, but rather as an administrative voluntary undertaking by the government. And the fact that it's voluntary and not de jure, we can see quite clearly from what the government has done with Jerusalem. Again, I think it's crucial when we talk about this to look at precedents from other situations, not to look at what the UN has said about this situation once they know that Israel is involved, but to look at also what the UN has said about Azerbaijan, about Northern Cyprus, and about many other territories, because the key law is the equal treatment of like cases. I yield my time.
Thank you very much. Dean Cover, you have 5 minutes.
So thank you. I think in terms of the applicable law, I don't disagree with your characterization of the Israeli government's position with respect to the Hague regulations and the Fourth Geneva Convention. But to be sure, the Israeli High Court has applied the Fourth Geneva Convention, has applied the Hague regulations to actions by Israel in the occupied territories, and has found the conduct of the Israeli Defense Forces to be lacking in numerous instances. That is the legal regime it has applied. I'm comfortable with this sort of gap filling. Law abhors a vacuum. We do need to understand what law applies. And so I guess it's still not clear to me if indeed we say that the law of international humanitarian law and occupation law does not apply in this context. What law then does apply? So is it Israeli civilian law throughout? And what then is to be the treatment of all Palestinians, right? And this, I think, inevitably does bleed into the political question. What then are the rights of Palestinians? If indeed the position that I understand Professor Kontorovich to be taking is that Israel enjoys sovereignty over all of the occupied territories, then indeed I think we have to look at international human rights that should apply. And then I think, we can look to provisions and analysis that is in the International Court of Justice, restrictions on freedom of movement that we see as a result, expropriation of land, deprivation of property without compensation. These are fundamental guarantees that are in the corpus of the law of armed conflict, but they are also, to be sure, guarantees under Israeli domestic law and under Israeli human rights law. And I think, look, this is where we see the political questions and the dithering. Part of the reason that probably explains politically why Israel has not annexed the territory, why many are ambivalent, why most Israelis do not necessarily clamor for or desire annexation, is it invites these questions. Right? What rights, what are Palestinians going to be treated equally? Are they going to be afforded full citizenship within these territories? And what will follow? What happens to the democratic character of Israel? I think, as I wanted to discuss a little further, look, I think we have to be honest. If the analysis that we want to, if people who are angered over annexation with respect to the West Bank, they should feel equal displeasure and anger over prior Israeli annexations, whether it is regarding Jerusalem or the Golan Heights, right? I think in many respects, the same analysis should apply. And so, I think those on the left who decry this plan probably need to be honest and recognize how that presents similar issues and how the occupation itself, whether it should be characterized one or not, continues to violate Palestinian rights. I think what I would just end with, is sort of a plea in our debates and in all of those of everyone's, is that so often these debates, I think, fall on two issues. One, issues of Israeli security, fear of its existence, and secondly, legitimacy of Palestinian claims. And I think defenders of Israel are inclined to all too often delegitimize those Palestinian claims, whether it is delegitimizing their personhood or delegitimizing their territorial rights. And so I think we need to have a franker discussion and embrace of both looking at the law, both as one of logic, but more importantly, as one of experience. And if my time has passed, I apologize and I yield the balance.
So with that, I'm going to turn this over to my co-president, Patrick, and he is going to administer our Q&A section. I believe we have some in the queue already.
Okay, so a question to both speakers, and thank you for coming and joining us, Eugene, once more, and thank you, Dean Cover. You both doing a terrific job. So here's my question to both of you. To what extent does the Jewish people's claim to being indigenous in the Middle East, with different Jewish populations living in Jerusalem, in parts of Judea, Samaria, what some people refer as the West Bank or the occupied territories, strengthen uninterruptedly, right? The Jewish people being indigenous and there and living throughout history in portions of Jerusalem and Judea, Samaria, uninterruptedly. To what extent does that strengthen the argument that Israel is not an occupying force, but reclaiming territory it once controlled and currently controls? Thank you.
Let me take that very briefly. So I'm a formalist. Again, as my analysis suggested, I think what Israel's sovereign status is turns on very few and limited facts, not on a broad-ranging moral and historical inquiry. The basic fact of Israel being the only successor state to the British Mandate is all one needs to know that there is not an occupation. The question of the Jewish people's indigeneity, which was in fact recognized by the League of Nations in issuing the mandate, may be helpful for making you feel better about that legal result, because sometimes I think Dean Cover adverted to this issue. Maybe we think the legal results aren't always aligned with our moral sensibilities, but by itself, indigeneity does not get you a sovereign claim. So, for example, the Kurds may be indigenous to Kurdistan, but that does not give them a state of Kurdistan. And I think it's very important in these discussions to separate moral and historical claims from legal title claims.
Yeah, I actually think I share much agreement with much of what Eugene says. I think in terms of if you're looking at the elements of statehood, I actually was recently discussing this with my international law class. You can look under maybe a constitutive approach where you look at the characteristics of sovereignty, of statehood. And in some cases, under the constitutive approach, whether you're looking at basic elements of whether the state has met it in terms of defined territory, permanent population, a government, capacity to enter into relations with others, in some instances, some will argue they will look at also this principle of self-determination. And so I think there is an argument to be made that those claims of indigeneity of Israel is a plus. To be sure, though, it's a competition of claims. And I think UN Resolution 242 speaks to that. The second clause speaks of terminating claims of belligerency, but also respecting and acknowledging sovereignty, integrity, and political independence of each state. I think embedded there is a principle of self-determination. It can speak to the Israeli Jewish people's personhood, but I also think it speaks to the Palestinian personhood as well.
So I'll ask a question while we get the rest of them in order. So to Eugene, human rights law, does that factor into your analysis as well? And to Dean Cover, Professor Kontorovich mentioned Udi possidetis juris. At what point do you think that that important concept gets trumped by humanitarian law and customary international law?
I don't think it's a question of getting trumped. I think it's a question, here, there's some room for, I think, disagreement on whether these claims of state succession apply here and as to borders. And there, I think I just have to disagree. And I think we've seen, in terms of the international community's consensus here, and Israel's own embrace. So I don't know, maybe I push back or maybe turn the question over to Eugene, I guess. What is to be, is it an act of grace then on Israel's part in terms of entering into these agreements, refraining from annexation, refraining from laying claim to sovereignty, but that, in mid-June of 1967 through to today, Israel at any point could have simply declared sovereignty over the entire land. I don't think that's been Israel's position, and I don't think it's just a political one.
So I think it has been Israel's position, and I think it has not stated it prominently, but I think it's most formally manifest in the Jerusalem law. So when Israel in 1967 immediately applied Israeli law to Jerusalem, it did so actually by passing two laws. One, which was the actual law extending the municipal borders of Jerusalem to a broader area, including parts of the West Bank. That's the famous one. But in addition to that, they needed to pass a law to be able to pass that one, because in 1949, the Knesset passed a law saying that the Knesset can at any time extend the authority of Israel to any place currently controlled by the military. But then when many more places came under control of the military, they amended it to make clear that Israel could extend and apply Israeli civil law and jurisdiction to any part of Eretz Israel, to the land of Israel. And they did this because it wasn't just Jerusalem, it was also areas outside of Jerusalem that were included in the new borders of Jerusalem. So that was Israel's position. Now, why did Israel not do it for so long? I think it's impossible to hide from the fact that there was overwhelming international pressure not to do so. Indeed, when Israel reaffirmed its sovereignty over Jerusalem in the early 80s, it was met with an outpouring of international hostility and movement of embassies. And it is very hard to also pretend that throughout much of the time, the Soviet Union did not have as one of its key foreign policy prongs to push back on this and organized much of the world behind it, something, an effect which is only, fading. So Israel was, a small and weak state and had to pick its battles. And the fact that it was, constantly being threatened, even now when Israel speaks about doing this, the Europeans threaten vast consequences. So when there are explicit threats of horrible consequences, you don't need to assume some kind of legal analysis for not doing what you're being threatened to do. What you're being threatened if you'll do it. I think that's the simplest explanation. And then people say, why now all of a sudden? Because because it's become politically feasible. Because there's a narrow political window because of the Trump administration.
Okay, so how is the British mandate consistent with international law if the mandate was given without the consent of the Palestinians and granted Israeli land where Palestinians were living? How does this affect Israel's sovereign claim?
Pretty much all borders of pretty much every country, whether it was without Israeli consent, it was without anyone's. It was with the consent of the League of Nations. Now, the League of Nations, so again, let's step back. You're asking a question about Israel. But you should always reformulate the question to be a general question so that when don't cloud it. So, for example, all League of Nations mandates were given without the consent of anyone. And there's like 20 some of them. The mandate for Syria was given without the consent of the Kurds, the Druze, or even the Alawites or anyone. The mandate for Lebanon was given without the consent of the Sunni majority or the Christian, the Sunni minority, or at that time the Christian majority. The mandates for Togo, the mandates for Cameroon, the mandates for Rwanda, Burundi, the mandates for all of the Pacific states. Right? There are many, many mandatory. Transjordan, the Palestinians never consented to a British mandate for Transjordan, let alone to have it be run by a Hashemite monarchy. Nobody doubts the international legality of the Hashemite Kingdom of Jordan with its present form of government and its borders, but it is solely created by the League of Nations mandate. So if you think that the mandate system is problematic and all borders that were not like voted on somehow by people, which is pretty much all the borders in the world, are problematic, then we need to first start by erasing Syria, Lebanon, Jordan, Iraq, many African countries and many Pacific countries, and starting with plebiscites there. That's not how we approach things, because stability is also the value in international law.
I only wonder whether I might add, but by asking a question, because I don't know that I had full clarity on it, which was, so what law does then apply within these occupied territories?
So right now, the law that applies. So I'm a positivist. I don't think there's if there's a legal gap, there may be a gap, and but certainly there does not need to be an international legal framework. In my view, the law that applies is Israeli military law that Israel has applies because it has chosen to govern it militarily, much like the U.S. has chosen to govern various territories for a long period militarily, but fundamentally under Israel sovereign authority with a very special super hyper autonomy agreement with a Palestinian autonomous government, which enjoys levels of independence and autonomy unknown in the annals of non-state self-determination, by which the Palestinians administer all of their internal affairs and conduct their own elections. They are neither taxed nor legislated for by the Knesset, which explains why they don't vote for the Knesset, because just like there's no taxation without representation, there's no representation without taxation, and the Knesset does not claim the power to tax Palestinians under the current agreement with the Palestinian Authority. Palestinian Authority has exclusive competence in those matters. So in the areas governed by the Palestinian Authority, Palestinian law applies. That's why they pay people for terror attacks, not because Israel has a law giving social security benefits for terror attacks, because the Palestinian legislature passed such a law. Israel doesn't like it, but it can't overrule it.
Right. Although, I mean, to be clear, within that system that you described, if military law is being applied, then the governing regime remains, right, the Hague regulations and Geneva, which is both a source of authority and it is a source of limitation.
But a selective approach to the Geneva Convention, because Israel says only certain parts
only the humanitarian provisions, right?
The Hague, they accept more generally.
Yes. So I think, the question is, if you look at the structure of law within the current occupation, to be sure, Israel is applying much of its law as well to the Palestinian population. It's not simply Palestinian law being applied. The military detention system that exists through much of the territories is not applying Palestinian law here. In some cases, it's applying Jordanian law, it's applying British law, it's applying military law. And so we have a system here that, if we want to agree, then, it's a regime of occupation law still being applied. It's outlasted any reasonable bounds of occupation.
But it's not a formal regime of occupation law, because no one would say, people who believe that it is really an occupation don't think Israel is doing a proper job of applying occupation law, because Israel isn't really trying to do that. They're trying to just have some rules for the sake of it. And if that's the case, then if they change their mind and decide to, in parts of this territory at least, apply direct Knesset legislation, then that would be it. So, for example, Israel does not claim Article 49.6 of the Geneva Convention applies. They say, why does Israel, not think there's a problem with settlers? Because they don't think it's a de jure occupation.
No.
So they're not applying occupation law of its own force. In some areas, they've implied direct Knesset legislation.
Looks like we have a final question, and I will read it for you guys. Palestinians who live in Area C are systematically denied permission from the military to build on their own land. The reason given is because a city's plan is needed, but even when such plans are provided, the majority of requests for natural expansion, a room for expanding family, is denied for Palestinians and not so for Israelis. How do you explain this?
The plans that are presented are often just problematic from a planning perspective. But by the way, there's a factual debate here, and it's hard to assess factual debates in this kind of forum because we have very little time. So I'll just skip to the punchline and say that I very much think it would be wonderful to get rid of this crazy situation where the military is responsible for giving planning permissions to Palestinians in Area C, and Israel should apply Israeli civilian law to it, and have one clear standard where it's all governed by regularized municipal planning systems. But the people who complain about the lack of permissions for Palestinian zoning rarely would embrace the actual solution of applying a consistent set of civilian laws. I would also point out that 0 Jewish plans for building have been approved in Area A or B by the Palestinian Authority ever, and Mahmoud Abbas has actually stated that he believes his country is entitled to begin its new existence when it is created free of any Jews. So that's a difficult thing to explain also.
Yeah, I mean, my only response in part to that is, I share some agreement with Eugene in that I do think some of it is a product of the military occupation law that is applied. It is one that will continually favor the occupant. So even though occupation law suggests that the military is acting as a custodian, security interests will always predominate in an analysis. And so I think, biases play out there. With respect to expansion or where, of course, settlements are growing, it is worth noting as a factual matter, in the 70s, there were only about 5,000 settlers living in the West Bank. By the 90s, it was 100,000. And now there are 350,000 in the West Bank. And so, whether we call it annexation, occupation, what have you, the settlements are growing at a significant rate. I think facts on the ground are being created in a problematic way. And so indeed, whether we call it annexation or anything, Israel is laying claim to much of this territory.
All right. Well, I think we are out of time, but I want to thank both of you a lot. This was a really great debate. I'm very sorry we only had an hour to go over this. We could have given 3 hours to each of you, and it still wouldn't have been enough. But thank you for your participation. I really enjoyed it. I liked seeing you two go at it. And thank you again. Hopefully we'll have you back soon.
Thank you.
Take care.
We would be pleased to send a complimentary DVD of this program to anyone who wishes to support JBS with a tax-deductible gift of $36, double high or more. Simply visit the JBS website at jbstv.org and click on the Donate button to make a donation by PayPal or your credit card. And please indicate the program for which you would like a DVD. Or you can send your tax-deductible check to JBS, Post Office Box 360, Stamford, Connecticut 06904. Or you can call the JBS Pledge Line at 833-MY-JBS-TV. That's 833-695-2788. And again, please remember to indicate which program you would like to receive with our compliments. We thank you for your kind support.